Good afternoon, friends. This video about steps that you are going to have to take once USCIS approves your petition. Thank you very much for watching. My name is Alina Shaltsova. I'm an immigration attorney from New York. I've been practicing immigration law in the United States for almost 16 years, and I help clients not only from New York, but from all over the United States and overseas. So if this is your first time, welcome. Please don't forget to subscribe to my channel, and let's start. Once an immigrant petition is approved by USCIS, you will have choices depending on where the beneficiary of this petition is and whether the beneficiary of the petition may adjust status in the United States. These choices would be either to go through a consular route or through adjustment of status route. A consular processing route implies that beneficiary of the approved immigrant petition is going to file for a visa with a U.S. consulate overseas. Adjustment of status takes place when the beneficiary may receive a green card in the United States. For more information as to how to receive a green card in the United States once your petition is approved, or to go through adjustment of status, please watch this video that I'm also publishing a link for in the description here below. Now let's talk about the consular processing routes and steps that one will have to take once their petition is approved. Let's take a family-based petition, and let's assume that the family-based petition is current. You may know that in the family category of sponsorship, as well as in many employment-based categories, you have to also make sure that the petition is current prior to engaging in further process with National Visa Center, USCIS, or Department of State. You may check the line or whether or not the petition is current by looking at the visa bulletin, which is containing information as to priority dates in preference categories for family petitions such as F2A, for example, F2, F1, F4, and for employment-based petitions such as EB2, EB3, and of course EB1, even though EB1 category is almost always current for majority of the countries. Now, when we determine that your petition is approved and it is current, your next step would be to wait for USCIS to create a case for you with National Visa Center and assign that case a special number. After that, you're going to receive fee payment invoices for affidavit of support and for immigrant visa. Those invoices must be paid as soon as possible, usually after you receive them. The next step would be to submit required documents, upload them through a special portal, a link to which also will be emailed to you by the government. Those documents typically include proof of the relationship between the petitioner and the beneficiary, beneficiary's passport, beneficiary's birth certificate with translation, information where applicable about the beneficiary's family members, criminal background checks, and of course, affidavit of support, Form I-864 with supporting documents. Once all these documents are uploaded to the portal, you will have to wait for NVC to review them. And only after NVC says that the case is documentary qualified, beneficiary may hope that an interview will be scheduled. But prior to that, the beneficiary also has to fill up Form DS-260. This is an application for the immigrant visa. Without that application, no case is going to be scheduled for that immigrant visa interview. Once you have the date for the immigrant visa interview, your beneficiary has to schedule the medical exam. The medical exam is scheduled only with doctors that are authorized to perform such an exam by U.S. consulate. To locate such a doctor, you usually have to visit the website of the U.S. consulate in the country in which your beneficiary is going to have their interview. Make sure that you do it right away, that your beneficiary schedules that medical exam right away, not to cause delays and postponement of the immigrant visa interview. Final step, or what should be the final step, would be the immigrant visa interview that your beneficiary will have to attend. After that, usually within a week maximum, as a rule, consulate is going to make the decision and either deny or grant the visa. But in some cases, there is no denial or grant. There is something called 221G, administrative processing, where a consul is taking unlimited time and unspecified time to review your beneficiary's case and make a decision to grant or deny their visa. Unfortunately, the 221G administrative processing review is not controlled by any deadlines. And if your beneficiary's case got stuck in that review, please contact our office and we see how we can address any potential issues that consulate may be investigating. This is a typical process for somebody to receive an immigrant visa if their petition was approved. I hope you enjoyed this video, and if so, please like and share it, subscribe to my channel, and I hope to see you soon.